to a front page story in the Gleaner. No IC privacy breach. Financial institutions obliged to furnish information on MPs and other public servants. This report obviously caught my attention for a number of reasons. The first of which is, as you are aware, there is a joint select committee of Parliament now examining the provisions of the Integrity Commission Act, an act which came into operation in about 2018. And when it met last on the 25th of June, before the Joint Select Committee were various recommendations from a number of different entities, including the Permanent Secretary's Board. And appearing before the Joint Select Committee at the time were representatives of the Solicitor General's office and the members of that Joint Select Committee. This particular matter concerning the potential breach of privacy rights, it's a recommendation made by the Permanent Secretary's Board for consent of an individual to be given before the Integrity Commission can seek to get information from an outside body such as a financial institution and so forth. And fascinatingly, at some point in time, I have to find that excerpt to play for you, because I remember when the Observer put an article in the paper concerning what transpired before the commission, the way they interpreted what transpired and the way I understood what transpired from watching it. They were not on all fours. But based on a question from Dr. Maurice Guy concerning banks being compelled by the court to turn over information on public officials and parliamentarians to the Integrity Commission, the issue of a request was made actually by the members of the Joint Select Committee for the Solicitor General's Department and the Solicitor General in particular to perhaps get a copy of the court order so that the Joint Select Committee could see whether it has general application or whether it was sort of specific to the matter before the court. And I recall the Solicitor General saying, well, you know, it's going to be difficult because you have to do some research. You don't really know the parties and so forth. Imagine my shock when I got hold of the decision earlier this morning, and just having a look at the parties in the matter, I've now realized that it is not only the financial institution that had an issue with the request for information by the Integrity Commission, and the Integrity Commission who were actually present in the matter, but the Director of State Proceedings actually appeared for the Attorney General of Jamaica. In other words, there was a representative of the AG's department that made submissions to the court in that specific case that the Joint Select Committee was seeking an order for. I'm not going to hold that against the Solicitor General, because I know that sometimes with the volume of things that, go on and which people have to sort of pay attention to, one might forget. When I look at this decision this morning, the fascinating thing is the court says that the essence of the Attorney General's submissions, the essence generally supported the application by the Integrity Commission. So the court confined its attention to the Commission's application and to Barrita's opposition of it. And I'm surprised by this position, which is put forward in the court, because I got the impression from what was coming out in the Parliament that there's a general sort of opposition to the thrust of having the Director of Information and Complaints in particular make requests from third-party institutions for information, especially if it is not within the context of an investigation. And specifically, the Director of Information and Complaints has no business or duty carrying out investigations, so that individual shouldn't be making any requests to third parties, banks, financial institutions, or so forth for information on any individual. But the submissions in this case, they are completely on the opposite side. Let me take a break. The Joint Select Committee, a number of the members, led by Delroy Chuck, they appear to be of the view that a case coming from the Turks and Caicos, where the Integrity Commission in the Turks and Caicos and this entity, a liquidator, Kiki Varakis, as official liquidator, TCI Bank Limited in liquidation. They were of the view that this case is somehow persuasive in that the consent of an individual is to be sought before the Integrity Commission can embark on seeking the information from another body. That was the original position by Mr. Chuck, and which was that position was supported by other members of the Integrity Commission. I then understood from the Solicitor General's Department that they were saying, really, when you look at this Section 7 in our law, it appears as if the Integrity Commission could seek information from a third party without the consent of the individual on whom the information is being sought. And in the first instance under Section 7.2, that third party shall cooperate with the Integrity Commission and in essence turn the information over. But should the entity not cooperate and turn the information over, then under Section 7.3 of the Integrity Commission Act, the Integrity Commission can then apply to the court without notice to the institution from which it sought the information. And it appears as if the court shall compel the production of the information. Right? And the view, I'm not even sure in the end how the matter ended before the Joint Select Committee, whether they are seeking to amend it to ask for consent or not. But the important thing at the moment is that we have a decision of the court that was made on the 17th of January 2024. The written decision was only delivered perhaps a day or two ago, and based on the written decision, the court was asked to interpret the meaning of the words shall cooperate, and the meaning of shall cooperate, it has been read to be that it's an act of compulsion of third parties to hand over information on any entity, on any individual that any director of the Integrity Commission seeks. It could be the Director of Informations and Complaint, it doesn't matter. It could be the Director of Investigation, it doesn't matter. It could be the broader Integrity Commission itself, it doesn't matter. Whatever is sought under Section 7.2, the court is actually saying the cooperation is an act of compulsion. And it came about in the context where, this is also interesting because I've seen so many instances, I believe, where, let me hold off on that for the moment. I need to just double check something. This is the context. By a letter dated the 28th of June 2021, the Director of Information requested the court cooperation of First Global Bank and Barita Investments Limited to provide information in relation to accounts which they'd been holding for parliamentarians and public officials who'd filed statutory declarations. The financial institutions were asked to provide in respect of each person named in an attached list balances on bank accounts and other financial investments, the dates on which the account or accounts were open and their status. And this information was required as part of the process of verification of information provided in the statutory declarations. In making the request, the Director of Information relied on Section 7 and 32 of the Act. This is the Director of Information and Complaints, the person that has the responsibility in law to verify the statutory declarations. This is not the Director of Investigation, which goes about investigating all sorts of things, including illicit enrichment and all those things. Right? And the court says that First Global declined to comply, citing its duty of secrecy under the Banking Services Act, and requested that the commissioner seek an order from the court for them to cooperate. Barita, in declining to comply, relied on their obligations to protect their clients' personal data, together with their view that cooperating, quote, would require too wide an interpretation to support a clear legal obligation on Barita to provide the commission with the client's information. Additionally, Barita questioned whether the role, functions, and power of the Director of Information included the authority to request the information. In view of this, Barita also requested that the commission obtains a court order to permit their cooperation. So, the proceedings were then started by the commission for declarations on the interpretation of that Section 7, and the Section 7 is the one that stipulates the need for cooperation between the Integrity Commission and persons or other bodies. And they sought an interpretation as well and orders directing Barita and First Global to comply with the requests. By order of the court, Barita, First Global, and the Attorney General were served with the application and invited to make submissions. In other words, even though the law allows the Integrity Commission to go to the court for orders without notice, the court in this case, as happens in many, near all instances where you go to the court without notice to the other party, the court is now based on a decision in the coming all the way from the Privy Council. I think it's NCB and Olint case. And that's specifically in relation to ex parte application. The court says sometimes even a phone call is sufficient. So they normally order the party who comes without notice to go and serve the other side. In this case, not only did the court order for Barita and First Global to be served, but they also asked for the Attorney General's Department to be served and for those served to make submissions. So by the time it got around to the nuts and bolts, though, First Global decided they won't challenge that anymore. So they complied with the request of the commission, and so the matter went forth with the Integrity Commission against Barita, and then the Attorney General's office continued. And the Attorney General's office filed submissions which generally supported the commission's application. So one has to go back and listen back to some of what was stated in the Parliament on the 25th of June and to perhaps erase it because, for whatever reason, the Attorney General's Department, in this case, the submissions were completely different from the views expressed in the court by Lisa White for the Director of State Proceedings for the Attorney General. And the essence of this case is one is compelled within the context of the wording to cooperate. You are compelled to turn over information to the Integrity Commission when you are requested to cooperate. And all of this gives, there are a lot of issues, a lot of questions arising here, because it doesn't seem to me, based on the provision in Section 7.3, which authorizes the Integrity Commission to go to court for an order without notice to anybody that it is going for that order to compel the production. If the Parliament intended the cooperation section to be compulsive, it would not have included the section where it allows the Integrity Commission to seek the order to compel. But the court seems to have read 7.2 and 7.3 as having the same effect. And when you're asked to cooperate, except if, I suppose, legal professional privilege applies, which is represented in another section of the Section 7, unless legal professional privilege applies, you are compelled without more to turn over whatever information is requested of you. And then the other thing is, we always talk about fettering of the court's discretion. If Section 7.2 of the law, which says that a person or body shall cooperate with the Integrity Commission, if it is read as being compulsive, then it seems to me that even when, if somebody for whatever reason thought it wasn't compulsive, but it is sort of discretionary, and they don't comply, and the Integrity Commission goes to court under Section 7.3 to seek an order of the court, it seems to me that the court, it appears, under this law doesn't even have a discretion to say, no, the entity can't turn over that to you all the Integrity Commission perhaps needs to say is, we asked for an order to cooperate under 7.2, and there has been no cooperation, so you are duty bound to grant the order that we seek. Certainly based on this particular decision. But the fascinating thing here, there perhaps will not be any appeal, because the position of the AG's department in this matter, it was one and the same with the Integrity Commission. And I don't suppose that Barita Investment will have any great interest in furthering this matter by taking it to the appeal court. The fact that the oral decision was handed down January 2024 and the written decision comes now, then maybe there is some time for an appeal to be mounted, but you perhaps don't even have an appellant. Yeah? And I think that this is something that needs to be tested further, but there's no testor. We're trying to find the AG's department to understand why is there this gap between the submissions made in the court and the ones that were made before the parliament. It would be good to hear.